Be ready. 5 seconds. Start. Insofar as appellant number 1 is concerned, comma, it is difficult to sustain his conviction under section 498A of IPC. Stop. The deceased in her statement has accused only her mother-in-law and sister-in-law for this demand. Stop. She has not blamed her husband at all. Stop. On the contrary, comma, she has categorically stated that her husband is innocent. Stop. Maybe at times, comma, appellant number 1 had beaten his wife on the saying of her mother-in-law, but the deceased had not connected this with demand of dowry. Stop. Therefore, comma, it is not conclusively proved that there was any cruelty on his part. Stop. Here, comma, reading the statement of the deceased along with various letters becomes somewhat important. Stop. Tenor of those letters, comma, insofar as they relate to appellant number 1, comma, indicates that as far as appellant number 1 is concerned, comma, he is not to be blamed. Stop. In fact, comma, in order to please and satisfy his wife, comma, appellant number 1 was making all efforts to become something in life and was struggling for that. Stop. We thus, comma, are persuaded to give benefit of doubt to appellant number 1 for change under section 498 of IPC. Stop. As a consequence, comma, while upholding the conviction of appellant number 2 under section 498 of IPC, comma, we acquit appellant number 1 from this charge. Stop. Para. With this, comma, we come to the question of conviction under section 304B of IPC. Stop. It is couched in the following language. Stop. Para. Where the death of a woman is caused by any burns of bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for, comma, or in connection with, comma, any demand for dowry, comma, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. Stop. Para. Undoubtedly, comma, death of Shrimati Sunita is caused by burns and has occurred otherwise than under normal circumstances. Stop. It has happened within 7 years of her marriage. Stop. Further, comma, the trigger point for committing suicide was the quarrel between her and her mother-in-law on the fateful day. Stop. At the same time, comma, it is also to be borne in mind that it is not a case where appellants have poured kerosene and put her on fire. Stop. That is the act of deceased herself, and thus, comma, it is a case of suicide. Stop. The question is whether the quarrel between the deceased and her mother-in-law can be treated as satisfying the condition, comma, that soon before her death she was subjected to cruelty or harassment for, comma, or in connection with, comma, in demand of dowry. Stop. On the reading the statement in totality, comma, it becomes clear that cause or reason for regular fights was dowry. Stop. One can clearly find out from the statement that on what day also appellant number 2 fought with her for that reason. Stop. We are, comma, therefore, comma, of the opinion that commission of offence under section 304B of IPC against Appellant number 2 stands conclusively proved in view of iron-clad dying declaration. Stop. Here again, comma, for the reason stated by us while discussing the accusation against appellant number 1 under section 1 498 of IPC, comma, it cannot be said that he had committed any act of cruelty soon before her death which forced the deceased to take such a step. Stop. She has nowhere stated that on that date when her mother-in-law had quarreled with her, comma, appellant number 1 was associated or even responsible for that. Stop. We thus acquit appellant number 1 of charge under section 304B of IPC as well. Stop. Para. Coming to the sentence of appellant number 2 in respect of aforesaid offences, comma, we maintain the sentence of 1 year rigorous imprisonment for offence under section 498 of IPC. Stop. However, comma, insofar as section 304B of IPC is concerned, comma, we are of the opinion that there are certain extenuating and mitigating circumstances which persuade us to reduce the sentence of 10 years RI as awarded to appellant number 2. Stop. First of all, comma, even when the immediate causes to commit suicide was the fight, comma, at the same time, comma, it has to be kept in mind that the deceased was not happy with her matrimonial life for other reasons as well. Stop. In fact, comma, she was not happy with this marriage at all, which she stated in some of the letters to her Mosi or Mosa. Stop. We are of the view that ends of justice would be subserved by reducing the sentence from 10 to 7 years rigorous imprisonment. Stop. The appeal is partly allowed in the aforesaid terms. Stop. The appellant number 2 shall be taken into custody to serve remaining sentence. Stop.